how we got where we're at, what we've discovered along the way, and then turn it over to Dr. Bhattacharya to talk about his experience, um, his expertise, how he got involved in this, and what sort of his observations are. There's been a lot of media surrounding this, certainly this week, but also in the lead up to this, because I really do fundamentally believe that this is the most important free speech case, certainly in our lifetime, but I think you could argue in American history too, because we've clearly entered the digital age. And if you think about, kind of traditional First Amendment law, it's been centered around kind of the public square, what you can say, in that kind of town hall or public square setting. Now, of course, a lot of people, like we're doing right here now, have conversations and debates and opinions on social media and online. And what this case gets at the heart at is what is the government able to do to censor speech by partnering with private parties or coercing private parties. And so, in this instance, you had, at the behest of some of the highest ranking government officials, in the country, moving social media companies, some of the biggest companies in the history of the world, to silence Americans. I mean, that's what was happening. And so I think it's also instructive to kind of go back in time a little bit to 2021, or even when we filed this case in 2022, and really remember where we were at, where the narrative that was being pushed by the government, there was no room, according to them, for anyone really to disagree, and they were open about this. And so a lot of people have asked me what sort of spurred you to file the lawsuit. It kind of came on the heels. We had been very in Missouri, where I was Attorney General at the time. We have been very active in kind of pushing back against what I would dub as COVID tyranny. Missouri, we actually had the first vaccine mandate cases that made their way to the Supreme Court. We won on those cases. We sued 60 plus school districts in Missouri for their forced masking policies. So we were very active in kind of pushing back, because you just knew that people could make their own decisions on these things and not have the government mandate these sorts of policies. The idea that OSHA, which was an agency created to make sure forklifts beep when they back up, was going to force a medical procedure on 80 million Americans seemed kind of tyrannical to me, which is why we got involved in that case. And of course, with masking of school age kids, there was no science to support this. And you see now, of course, the studies that show how detrimental it was to kids psychologically, emotionally, loss of learning, all of those things. And so a lot of the things that I know the good doctor here was talking about, and others were talking about. But there was certainly an effort to silence dissent. And you started to see it. Jen Psaki would stand at the podium talking about how they were flagging posts. Of course, we even got to the infamous Disinformation Governance Board with Mary Poppins herself being put in charge of that, which was very dystopian. And it was around that time that we had seen enough publicly that we felt like there was a lot more there, that this was a concerted, all of government approach to take down, deplatform, and silence people. And so we filed the lawsuit. And one of the things that's key, that probably is underreported, when we filed the lawsuit along with Louisiana, we were able to get, in addition to the plaintiffs that we had on board, we are also able to get discovery early on, before the preliminary injunction, which of course we received on the 4th of July, and a great opinion by the judge there, the district court judge, who did liken this to sort of Orwellian measures, and in the this vast censorship enterprise that we outlined in the complaint, was certainly criticized by the judge as the most oppressive censorship regime in their nation's history, based on the evidence. And so there's 20,000 plus pages that were submitted to the court. We were able to take the deposition of Anthony Fauci. We took the deposition of Elvis Chan. Elvis Chan, of course, was the FBI agent in charge in the Northern District of California there, pre-bunking the Hunter Biden laptop story. They had the laptop in the fall of 2019. Yet we're telling these social media companies, be on the lookout for a Russian hack and leak operation. And then, of course, the one of the Twitter executives in a sworn affidavit with the FEC says, yeah, he specifically mentioned the Hunter Biden laptop. So they were pre-bunking that. And then when you really get into the crux of all of the censorship regime was really during the COVID times, 2021, 2022, where, again, this leviathan of government agencies was involved in suppressing speech. And so, origins of COVID, the lab leak theory, discounting natural immunity. I'm sure Doctor will talk about that as one of the authors of a really important work, the Great Barrington Declaration. But just quickly, I suppose it's worth noting we took the deposition of Anthony Fauci at the NIH headquarters in Washington in Bethesda. And it was, I think he said, I don't recall, it was like 174 times for this guy who proclaimed to be the science and this all-knowing being that could tell everybody what they were supposed to do on a daily basis. And by the way, not spend time with your loved ones on Christmas. He didn't remember a whole lot, but what he did remember was, we was presented with an email where he told a friend of his, yeah, masks are ineffective. You don't need to wear those on the plane. Of course, changed his position publicly on that. And then had an interesting interaction with a court reporter who, I kid you not, sneezed. And this is in November of 2022. Like, this is almost 2 years later. Asked her to put a mask on if she at that time. So anyway, this was the mental state of the all-knowing and all-powerful Dr. Fauci. But through that process, that is where you got the victories that we got at the district court level, and then, of course, at the Fifth Circuit Court of Appeals that showed, again, not just cooperation, but also coercion. And if you think about this in that context, these big tech companies have something called Section 230 immunity. They can't be sued because in 1996, they were determined to be a platform, not a publisher, not an editor. So they got special legal protections because the thinking was this was going to be a democratization of information. People could post, they could have their points of view, but what they've turned into, of course, in instances like this, is something different than that. But the government actually sort of holding that over their head, or even the threat of investigations, is what really crosses the line here. And if you, and it was mentioned in the oral arguments, but some of the exchanges from, again, highest ranking government officials in the country, the Surgeon General of the United States, who happens to be Murthy, who, it's Murthy versus Missouri now, who appealed the Fifth Circuit decision, along with the other government actors, that you take it down or else. They had special portals created, weekly censorship meetings. And so all of that, really, if you lay all that out before the court, so regardless of, what you heard, and we could talk about it as far as the oral arguments go, the court has all of that in the record. And so we were able to get that discovery before the preliminary injunction hearing. And I think that ultimately to us is the best thing going for this case, because it's all out there for the justices to see. So clearly, and I'll turn it over here, but for me, fundamentally, in this country, a very uniquely American idea is that we can speak our mind, that we have a right endowed by our Creator with certain rights, including the ability to express ourselves. And the government shouldn't be involved in telling us what we can say or what we can hear or what we can listen to or what our opinion should be. It's not the arbiter of truth. We are, as individuals. And so really the heart of this case, it cuts really to the core of what it means to be an American. And the government can't outsource the censorship to these behemoths, these social media companies. They can't get around the Constitution by having somebody else do it for them. And that's ultimately what this case is all about. And so with that, I want to make sure I introduce Dr. Jay Bhattacharya, who is a plaintiff in the lawsuit. And he's I won't go through his resume, his CV. It's very impressive, but he's certainly no stranger to censorship when it comes to speaking out against the quote unquote approved narrative on COVID-19. And so, Doctor, I wanted to get your take on this, the arguments, the issues of freedom of speech, the virtual town square, and what your experience was with all this.
Senator, thank you for inviting me onto this spaces, and thank you for bringing the lawsuit. Just a bit of background on me on how I got involved with the case. So from the very very earliest days of the pandemic, so I am a professor in the medical school of Stanford, for decades. I've been studying infectious disease policy and for a long time, including publishing a lot of papers. And when the pandemic hit, I just knew that the lockdown strategies that we're following were not the right strategy. I did a study measuring how many people had already had COVID in early April 2020 and found a lot more people that had it, that it spread more widely despite the lockdowns. Um, and I got subject to all kinds of grief, both from my university and sort of the press. It just felt like a direct onslaught for the crime of doing science. Um, and I started to get very, very concerned about the school closures, the harms that the school closure was doing. And I got involved as a pro bono expert in a bunch of school closing cases, anti-lockdown cases in 2020. In and then and I got somehow I got in touch with your office when you were the attorney general in Missouri, and I helped with the anti-vax mandate cases and with anti-mask mandate cases. Some of which we won and some of which we lost, which is frustrating to lose. But still, I was really proud to be able to help try to restore some sense of sanity into the policies of scientists. It was just appalling to me to see bad scientific ideas adopted as policy, and then that leading to the harm of tremendous numbers of children, of working class people, of poor people, and without even protecting people from COVID. Huge numbers of older people, vulnerable older people, died despite all of these policies, which had very little scientific basis. And one of the things I noticed while I was involved with this, with all these debates, is that it was basically impossible to get your word out about scientific studies and results without facing it on social media and elsewhere. This sort of like very strange. Sort of interference with, so like, for instance, friends of mine would tell me that they would put posts on LinkedIn, on Twitter. The old days it was called Twitter, and they would get labels placed on it as if they were somehow telling people lies when all they were doing was posting papers that went against the narrative. The idea that scientific debate has some high pope that can determine ex ante, which is true and which is not, and then label the side they don't like as untrue. I mean, that just runs anathema to science. My colleague Martin Kulldorff, who wrote the Great Barrington Declaration with me, he at one point during the pandemic, he posted a tweet, a very sensible tweet, saying, "Look, the saying that the vaccine should be this advice should be the same for everyone, especially when there's 1,000-fold or more difference in the risk of of dying from COVID between old and young. It just makes no scientific sense." He got bumped off Twitter for that. I was in a policy forum with Governor Ron DeSantis in March of 2021, where my crime was I told the sitting governor of Florida, that there is no good scientific evidence, high quality scientific evidence supporting masking children. Certainly not masking children as young as 2 years old. I mean, the Europe didn't do that. I mean, they see the same science we do. Why did they choose something different? For that crime, there was a TV station that recorded it. They posted it on YouTube, and that video was taken down. It was so dangerous that YouTube decided that the people of Florida, the people of the United States, the people of the world were not allowed to see a sitting governor talking to a scientific advisor about some of the most important issues, scientific issues and science policy issues of the day. And I was just appalled. So, Senator Schmitt, when your office invited me to join as this lawsuit in Missouri versus Biden in August of 2022, I was absolutely thrilled, because I up to that time I wasn't sure who was really responsible for this censorship. Of course it's very easy to say, look, the platforms are doing it. Twitter, you could blame Twitter, you can blame YouTube, but the question is why? Why would they want to do that? Why? I mean, it doesn't make any business sense for them to suppress speech. Twitter very famously once Jack Dorsey, the former CEO of Twitter, very famously said that he was, from the free speech wing of the free speech party, if I remember right. So why would they want to suppress? And so the lawsuit has been eye-opening. The discovery you talked about, Senator, was incredible, because it turns out that it wasn't just the platforms acting alone. It was essentially the U.S. federal government was leaning on these platforms, telling them they must censor these people and these ideas or else. It's absolutely shocking. I mean, the especially on scientific matters, when Martin Kulldorff, Senator Gupta, and I wrote that Great Barrington Declaration. 4 days after we wrote the Great Barrington Declaration, Francis Collins wrote an email to Tony Fauci calling for a devastating takedown of the Declaration and us, and calling us fringe epidemiologists. What you had then was the very head of science, scientific establishment in the United States, the head of the NIH, essentially abusing his position to destroy the reputations of scientists who disagreed with him on scientific matters. And so many scientists, as a result, stayed silent. And so to me, this was the critical reason why I was so happy to join the lawsuit. I believe that science requires free speech to operate. If you do not have an environment of free speech, you cannot have science. If you have a high pope of science, someone who says unironically that if you contradict me, or not simply contradicting a man, you're contradicting science itself, and who holds the reins of power in the scientific bureaucracy, in the form of $10 billion or more, a lot of scientists are going to stay silent, even if they disagree with him. And to me, the federal role in the censorship apparatus was an incredibly important part of why science went wrong during the pandemic. And I think whatever else has been accomplished thus far through Missouri versus Biden, it has absolutely blown open the door to that. The entire public can see in the evidentiary record of Missouri versus Biden, a concerted effort by the Biden administration to suppress scientists who disagreed with them. And it was interesting to hear. I actually sat in on the oral arguments on that happened in front of the Supreme Court a couple of days ago, and the tenor of it was kind of shocking to me. Much of the argument took as its premise that that regular people were misinforming the world, and the government had a role in suppressing this misinformation. When in fact, during the pandemic, exactly the opposite was true. On item after item after item, immunity after COVID recovery, certainly, the nature of herd immunity, whether there's a stratified risk of from getting infected, with elderly people being much more at risk than others. On waning of vaccine efficacy, the wisdom of vaccine mandates, the inefficacy of masks, on item after item after item. It was the government that was misinforming the public. The government was the number one source of misinformation. Free speech would have protected the public against that misinformation. There are people that are dead today that would be alive had the government allowed free speech to counter the misinformation the government itself was putting out. And so, to me, the oral argument sort of missed the whole point. The whole point of the First Amendment, at least as far as science is concerned, is to allow scientific discussion to happen openly, and in a way that the public can see. And the censorship regime we had damaged science, damaged public health, and ultimately damaged people. And so I'm quite proud of being able to participate, and I'm grateful to you, Senator Schmitt, for initiating the lawsuit.
Well, listen, you've been a great advocate for a whole bunch of things, but I think um, your take on, and we were on Laura Ingraham on Monday night, and you said something similar, which is, for science to move forward, it requires questioning, constantly questioning assumptions. Otherwise, there are no improvements to be made, and people have to feel like they have the freedom to go do that, not to have some oppressive government telling them that they can't say certain things, they can't question certain things, they're going to be ostracized or lose their medical license. And I think it's, people, if you go back in time, that was happening. I mean, think about it. People weren't able to travel. You were going to lose your job. Like all of these things that we think are in some Orwellian novel, they were happening, and that's why when we refer to this as a sort of a vast censorship enterprise, it was Orwellian. It was a whole of government. This wasn't just a couple people who had a bone to pick, who were calling, to use some of the oral argument examples, calling an editor at the New York Times objecting to a story. I mean, this was going after companies who dared to have things posted on their platform that were receiving the benefits of government with an administration that could affect that, telling them to take it down or else. Special portals, weekly meetings. I mean, it was really, really onerous. And so I think a couple points that you raised too is that you have to be able to be able to openly discuss these things in a free society. I think we talk a lot about what it means. What does the First Amendment mean? There is also something very cathartic for our country to be able to express different points of view, because we don't believe in political violence in this country. We believe that you resolve these issues in these debates through persuasion, right? And people have to feel like they have the ability to go do that, right? They have to feel like they can have a point of view and they're not going to be politically prosecuted, or there's going to be, there just has to be this sort of openness. It's a pressure. I often refer to it as the First Amendment is not only the beating heart of our Constitution, it's a pressure release valve for these really important debates where you're going to have, sort of high emotions sometimes, but the way you resolve that is you're able to talk about it, which is why, Justice Jackson's question was so, and it's been, written about, was so revealing, I suppose, of how some people kind of view this. And her question was essentially like, if counselor, if we're to take your view of this, don't you think the First Amendment's really hamstringing the government? Well, of course, that is actually the point. That is the actual point of the First Amendment and the Bill of Rights, is to prevent government from affecting in a material way or infringing upon people's individual rights. And we actually happen to believe there's something inherent in who we are, in our willingness and desire to speak our minds. It's just sort of fundamental human expression. And so I think that the question was revealing, and that's kind of what we're up against. And, I think the lawyer for the government was also sort of making the case, justices, this was a once in a lifetime pandemic. Um, you know, that is what every tyrant and dictator has said since the beginning of time, to aggregate, accumulate, and exercise power, which is, these circumstances are so unique that you need to give me these powers, and I need to be able to go do this. And then all of a sudden people look back, or they wake up and they say, how in the world did we get here? How did we end up with a government regime that is infringing upon people's rights? And so the founders were very keenly aware of this dynamic. They were students of human history. They had seen what happened, and they had a unique opportunity to create a government out of whole cloth. Coming from, of course, the English common law tradition and some of the established, the precedents that have been established there. But they said, look, we're rebelling from somebody who didn't want us to get together. They didn't want us to speak our minds. And so we're going to create these safeguards in the Constitution, which of course happened after the Articles of Confederation, but these safeguards, structural safeguards, to protect individual individual liberty, right? And so when you talk about federalism and you talk about separation of powers, what's the point of all that? Same thing. It's a widely diffused power, so that no one branch, no one agency, no one person is ever too powerful. And what you saw during COVID, I think, was a very unique circumstance. Not necessarily the pandemic. We've had pandemics before. I'm sure we're going to have them again, but the willingness, I think, for people to go along and accept this idea that because I'm quote unquote trying to protect you, that nobody else has a say, nobody can object. And that's a very un-American idea, because it's not the first and the last time. I mean, I just, hearken to a debate that's going on. I mean, before it was, global cooling, global warming, climate change, but you listen to the language change. Now it's a climate emergency. And not to get too much into that debate specifically, but people will always use, who want to, again, exercise power, use the guise of an emergency. And you also see now everything is sort of a threat to democracy, and that justifies actions that no one would ever, contemplate before. This is a very dangerous road to go down, to sort of have these quote unquote existential threats that require the government to usurp certain powers. In fact, the First Amendment and protections like that were actually put in place for difficult times, for times of a quote unquote emergency. I've said, other people said there's no pandemic exception in the Constitution. And so at the heart of it, and if you kind of pull back from the facts here, which are shocking, when you get into the idea of, and it's hard to, in the limited time we're going to have here, to get into all these specific examples in 20,000 pages worth of documents, but the interaction, and this is not like, hey, we've got an op-ed we'd like for you to publish. I mean, this was the heavy hand of government saying, you're going to do this or else, or do you have any idea what's at stake here? And, let me remind you of who we are. And so, again, when you have entities that are benefiting, like from Section 230 protections, I mean, this is a real thing. And so, I've told people like that willingly they were wanting to do some of this stuff, but there were some times that they were pushing back, and they, in fact, adjusted their terms of service, their terms and conditions, and a lot of the internal notices. In fact, there's a document that came out. We made those changes because the government wanted us to do that. And so, it crosses the line here. And I think this case stands for a very important proposition that, again, we know and we believe that the government, well, it's accepted. I'm not sure everybody likes it, and amazingly, but that the government can't censor speech, but they also can't then create these sort of new state actors like they had here with these social media companies. Doctor, I don't know if you wanted to chime in on anything on that or anything
Yeah,
else.
let me try to say a couple of things I had on my queue for this. So one is that although it's me and a few other Aaron Kheriaty, Martin Kulldorff, and Jill Hines are the primary scientists involved, or health activists involved. Really, we are not actually the plaintiffs for this, and it's not even Missouri and Louisiana. It is literally every single person in the country was subject to this regime, either because you yourself had your posts policed, or that you were deprived of being able to hear speech that you otherwise would have been able to hear. This was so, in a sense, this is every single person in the country is represented in this, and it's a limitation on the power of government, because that power of government harms the interest of every single person in the country. Um, and the other thing I wanted to say, I want to think about is that it's not just that the White House and the FBI and the CDC and the Surgeon General's office and huge numbers of agencies suppressed free speech individually by sending letters and saying you have to do this or having this portal. It's that they systematically developed an infrastructure to suppress whole ideas at a scale. So, like one of the topics that came up during the oral arguments was about something called traceability. Can you trace the suppression of the suppression of a post to something the government directly said or did for this particular individual? If that's the standard, essentially the government can suppress free speech at scale whenever it wants, simply by never naming names, just naming ideas. They can take whole ideas off of the platter for Americans to see, just by saying by imposing a censorship regime using AI tools that are people like Kristen Ruby and others who have developed these ideas. And I could see it when I went to go visit Twitter headquarters, when I talked with Twitter engineers and after Elon took over. These sort of AI tools are very, very important part of how the censorship happens. And the thing is, the government doesn't always just do it directly. They do it indirectly by laundering their censorship activities to third-party entities like, unfortunately, I'm sad to say, including my own university, through this something called a Stanford Internet Observatory, which sort of winds their way into these companies. And then what happens is the government will tell those Stanford Internet Observatory, oh, you should censor these. It'd be really good if these ideas and these people were censored. And then Stanford Internet Observatory goes to Twitter or Facebook or whatever and says, here's the list of things we recommend you censor. And actually, last point, and I'll stop. It's ironically, even the White House itself, even the government itself, can get entrapped in this censorship infrastructure. There's a really funny thing that I think most people don't know about that was found in the Missouri versus Biden documents. In April of 2021. In April of 2021, the U.S. CDC put a pause on the J&J vaccine, and because they had found a safety signal. Now, in the White House shared this fact on its Facebook page. The AI algorithms tagged the White House itself as an anti-vax group, because it basically, the White House had been captured in the trap that it had set for others. It had been trapped in itself. When it shared the fact that the CDC is saying the J&J vaccine was potentially dangerous, the algorithms tagged the White House as an anti-vax group. And then you see Rob Flaherty from the White House sending nasty worded emails to Facebook saying, "How come our page is being throttled?" And then you see these Facebook employees sort of sheepishly say, "Oh, we've tagged you as an anti-vax group." You know, regular Americans didn't have access to that. They would get tagged even if they put true things online. You know, true stories of vaccine injuries, true facts about the scientific literature. You could get tagged, and you had no recourse. Unlike the White House, it's very, very elitist the censorship regime, and it harmed the White House's ability to get across true information as well. The censorship is just, as you said, a senator, truly an un-American kind of thing. And I'm still in shock that I didn't hear a full-throated rejection of the censorship industrial complex at the Supreme Court hearing yesterday, a couple of days ago. I hope that the Supreme Court justices come to their senses when they actually make the ruling.
That's right, and I think that again, the best case here is that because we have everything a record submitted with all these documents, I think again it's overwhelming, and hopefully it's a full-fledged endorsement of the right to speak your mind without government interference. And your point is well taken, which is to say, not only do we have plaintiffs who were affected in this instance, but when you're kind of dealing with these sort of third party moderators like these social media companies become tweaking the algorithm or throttling people. A lot of people don't even know they've been quote unquote injured because they don't have any idea that their ideas may not be seen by anybody because there's been an algorithm set. And so again, it's a unique case that kind of sets the stage for what's to come. And I do worry if the government is given a pass here, the formalization that we saw of this. I mean, because they were sort of unapologetic. I think they felt like they were the white knights here, wearing uh, trying to protect everyone, and that's just not how it works, right? Ultimately, the people get to have a say. And when you have that full and robust debate in the town square or now virtual town square, that's how you arrive at the best information for people to make their own decisions. And again, why this case is so significant. So, Doctor, unless you have anything else, if there's anything else you wanted to add, I want to make sure we're respectful of people's time, and just wanted to check in this week because the case was argued and it's gained so much interest, and for good reason. And maybe we'll have to do this again because I don't think this topic, no matter what the court does, it's not going away. It's just, I think people, because of the case, no matter what, their eyes, as you say, have been opened now to what we've dubbed in the lawsuit the vast censorship enterprise, or as other people have called it, censorship industrial complex. It's shocking. And when we filed the case, you got to remember, Elon Musk had not bought Twitter yet. There were no Twitter files, and there weren't congressional hearings on any of this stuff. And so many people, I think if those three things don't happen, if we don't file the lawsuit, Twitter's not bought, this stuff would still be in the shadows. And I think it's just incumbent upon all of us to make sure this doesn't happen again, and do everything we can to fight back.
Yeah, thank you, Senator Schmitt. I entirely agree. I think it's no matter what happens with the lawsuit, it's now the genie's out of the bottle. Everyone sees what was done. I just can't believe that Americans will allow this kind of activity to continue to allow that essentially the First Amendment to become a dead letter. And I think I hope the court does the right thing. But if it doesn't do the right thing, legislative action, certainly the idea that free speech is the basic tenet of the American civic religion, that's, I hope, not gone. And that's even more important than the First Amendment, I think. So thank you so much, Senator, for having me on.
Yeah, absolutely. And just a quick plug, I guess, for some legislative activity. There are two bills now that I'm in the Senate. I wish I could argue that case, but I do have a different job now in the Senate. But we filed two pieces that are relevant. One is, look, if Section 230 was created to protect these companies so they could be open platforms, you don't get that protection if you're going to be an editor or publisher, if you're going to censor. You lose Section 230. That's legislation I've got. And then also one that I think would change the culture inside the behemoth of these federal bureaucracies sometimes, including places like CISA, is if as an individual American, you can sue an individual government bureaucrat if your First Amendment rights have been violated. I think that would help change the culture dramatically, and change the dynamic here. And instead of one attorney general having to file a lawsuit, you could have an army of patriots who are standing up for their First Amendment rights. I think that'd be an important thing to do as well. So, well, thanks again, Doctor. Appreciate it. And thanks everybody for joining us. And I think collectively, all together, if we stand up for the First Amendment, that's where we want to be. If we believe in this country and what it stands for, and American exceptionalism, the American idea, it's the right place to be. We're on the right side of history here. So thanks so much, everybody, for joining.
Take care, everyone. Bye.
Bye bye.